Purposes of discussing the jury instructions to be given to the jury after the closing arguments, as well as the form of the verdict sheet. Madam Clerk, I have 3 printed copies of some draft jury instructions. Would you provide those to Ms. Elliott, Mr. Arbor, and Mr. Fawcett? We'll wait for the defendant. Thank you. Just wait. Just wait a second. All right, let me start again. We'll commence a charge conference for the purposes of discussing the jury instructions in the form of the verdict sheet. And I have 3 printed copies I've given to the bailiff. If you would provide a copy to Ms. Elliott, Mr. Arbor, and Mr. Fawcett. So for the record, I'll start by just simply reciting the pattern jury instructions that I believe are appropriate, and then I'll hear from each of you with respect to additions, corrections, objections, or suggestions. The first, 101.05 is function of the jury, 101.10 is burden of proof and reasonable doubt, 101.15 is credibility of witnesses, 101.20 is weight of the evidence, 105.20 is impeachment or corroboration by a prior statement, 104.70 is confessions, 104.50 is photographs, diagrams, maps, etc. as illustrative evidence, 104.94 is testimony of expert witnesses, 104.05 is circumstantial evidence, 104.10 is motive, 101.30 is effective defendant's decision not to testify. 206.13 is homicide. I've only included under the theory of premeditation, not under a felony murder theory. I have a peremptory instruction that an 8-inch chef's knife is a deadly weapon. I have a lesser included offense of second-degree murder, and we may well need to have a discussion about other lesser included offenses, but that's what I have in these instructions. Then with respect to 206.17a, we have attempted first-degree murder with respect to Nation Han. Again, that has a peremptory instruction that the chef's knife is a deadly weapon. The next instruction is 208.10 is assault with a deadly weapon with intent to kill, inflicting serious injury, with peremptory instruction that the weapon is a deadly weapon and that the injury is a serious injury. There's a lesser included offense of assault with a deadly weapon, inflicting serious injury. 204.25, there was a notice of aggravating factors. One I'm not sure was applicable. There were 2 marked. One of the factors was the defendant was on pretrial release at the time these offenses were committed.
At a sentencing hearing, there could be evidence of that.
All right. At a sentencing hearing.
At a post-guilt,
I think aggravated factors first can get dealt with that real finding. Is that correct?
Issue.
Well, the issue of whether the defendant took advantage of a position of trust or confidence to commit the offense, I mean, I've got that incorporated into these instructions here, and I'm not sure why it would need to be bifurcated on that issue. The other one.
Would you like to address that at this very moment?
No, okay. But I just, all right, I have included that one. I saw that there were 2 noted, and in any event. Then 101.35 are the concluding instructions. All right, so let me hear from the state first with respect to any objections, corrections, suggestions.
To get to the substantive charges, the state has prepared copies written instructions. The state would ask that you instruct as to 3 different theories of first-degree murder, all supported by the evidence, competent evidence in this case. One is premeditation. The second is first-degree felony murder, with the predicate felony being a felony assault, specifically assault with a deadly weapon inflicting serious injury on Nation Hahn under the continuous transaction doctrine. And the third, and extremely, from the state's point of view, appropriate, is the ambushed attack against Ms. Hahn, which is first-degree murder by lying in wait. These are the 3 first-degree murder, and then second-degree murder, and then not guilty. And that the jury could find the defendant guilty of first-degree murder under malice, or felony murder, or lying in wait, or on more than one of these bases if guilt is found as to first-degree murder. Those are the 3 first-degree murder theories the state would ask. Specifically as to felony murder, the evidence shows that the defendant stabbed Mr. Hahn with that 8-inch knife, that Mr. Hahn suffered to his left hand, lacerated tendons in his ring and middle finger, lacerated artery and nerve damage, and had to seek orthopedic surgery, and had numerous months and months of rehab. That certainly is a deadly weapon, that's certainly serious injury, and that is certainly an assault, a felony assault. And it occurs in the same course of continuous transaction, which that special instruction is included here. A killing is committed in the perpetration of a felony where there's no break in the chain of events leading from the initial felony to the act causing death, so that the killing is part of a series of incidents which form one continuous transaction. It is immaterial whether the felony, in this case the alleged felony assault on Nation Hahn, occurred prior to or immediately after the killing, so long as it is a part of a series, or incidents, which form one continuous transaction. That's the continuous transaction doctrine to support the felony murder charge.
And you're reading to me from what?
Let's see, that would be page 3 of the proposals. I think I highlighted, anything that's in a highlight is my language versus maybe more the standard pattern jury. Something like I've had to put in quotes like attacking with a knife or a special request. But what I'm speaking to right now is top of page 3 is the continuous transaction doctrine that would apply to these facts in this case, as the evidence clearly shows. And I believe counsel in the opening said that their client stabbed both Jamie and Nation. This all is connected in one series of transactions, and the evidence would support that felony assault with a deadly weapon against Mr. Hahn as the predicate of felony murder as to Ms. Hahn's death. The lying in wait, again, that is lying in wait from the case law. It involves an ambushed attack. No specific intent is required for lying in wait. It's a physical act. Intent is to engage in the physical act under the case law well established. In this case, there are 3 elements to lying in wait. 1, the defendant lay in wait for the victim, Jamie Hahn, that is, waited and watched for the victim in ambush for a private attack on her. That's from the pattern jury instructions. The next sentences are coming from various case law, which I'll speak about in a moment, which basically says that the presence of the attacker can be known. You don't have to jump out of the bush. Just their intentions must be unknown to the victim. The second element is the state must prove the defendant intentionally assaulted the victim, Jamie Hahn, by stabbing her with a knife. And third, that it was the proximate cause of her death. The pattern jury instructions even mention under the first element, first, the defendant lay in wait for the victim, that is, waited and watched for the victim in ambush for a private attack on him. And in the parentheses is, according to State v. Brown, in a proper case, the jury should be instructed that the victim's knowledge of the defendant's presence is not a defense. That's pattern jury instruction 206.16, murder by lying in wait, which again is a physical act. The I have various cases to could cite about murder by lying in wait if the court desires to look at those things. Even State v. Brown, which is the one mentioned in the pattern jury instructions, the reference to lying in wait about, hey, you don't have to be concealed behind the bush. You know, I can be standing there right there with you. You just have to be an ambushed attack. That particular case, a quote in that case, which quotes another Supreme Court case, says, quote, even a moment's deliberate pause before killing one unaware of the impending assault and consequently without opportunity to defend himself satisfies the definition of murder perpetrated by lying in wait. That comes from State v. Brown, which is the parens in the pattern jury instruction, which is citing a State v. Wiseman, to my knowledge, based on some research. The State v. Allison from 1979 was the first case to establish that the defendant's presence can be known by the victim and still be lying in wait. So those are the three substantive first-degree murder charges the state would request. And the evidence, particularly the defense confession, is that he gets a knife out of his backpack in the living room, family room, walks behind her back, gets the knife, then goes and for the first time stabs her in the back. She turns, screams. That clearly is an ambush assault by the defendant, and this jury is entitled to decide whether he is guilty of first-degree murder under the lying in wait theory.
All right.
Respectfully.
Okay. So let's, Mr. Arbor, if you want to go ahead and, or Ms. Elliott, and let's talk about the theories of first-degree murder with respect to Ms. Hahn. And let's just address that issue now, and then we'll come back and hit other issues.
First of all, with respect to the charge that the court has proposed, we have no objection to that with respect to the charge of Ms. Hahn on the murder charge, okay, as written, all right, by the court. With respect to the charge of the continued, well, the state, this continuous transaction is, and I'm going to address the two, that and the lying in wait. The continuous transaction is part of the felony murder clause when there's evidence that the person went to the place with the intent to commit a felony, and in the course of committing the felony, if the felony happens afterwards and the murder happens shortly before it, that it can be considered for the sake of first-degree murder. That's not the fact pattern here. I think the evidence is quite clear that the altercation occurred in an unexplained fashion because the testimony of Detective Morse was he never got a motive from Mr. Broyhill as to why this was happening. It was, and even the testimony of Mr. Hahn when they were talking about money, which seems to be a big part of the state's case because they started with Attorney Wallace's testimony, was that this was more of a premeditated and deliberate act as a result of some confrontation that they believe occurred between Ms. Hahn and Mr. Broyhill. It's sort of disingenuous to come in and ask now that this is some kind of ambush upon her. I'm jumping ahead because it's sort of tied in, that this was something that he did because he knew that this information about his the taking of money from the Brad Miller campaign account and all was the motivation for that. But I think that's been fairly called into question through the evidence that we've elicited. I don't think there's any evidence that's been elicited that suggests that Mr. Broyhill went over there with a plan. He never said that he did. There's no independent evidence that he did anything to that nature. The stuff about him leaving town and all that is trying to connect that to be some intentional act, as this is part of some intended felony for which he was going to leave. I think it's been fairly discredited by the fact that Detective Morse was told by Mr. Broyhill that all that was disclosed to him by Mr. Broyhill and verified through independent examinations of his computers and phones that he was planning a trip to kill himself. They didn't know about it. They didn't know about it until he told them about it. So it wasn't like and what he told them was very accurate with what he said. There's no evidence that Mr. Broyhill was going over there for any planned attempt to commit a felony, even a felony with a knife, and that this was an event that happened in a sort of spontaneous event that we believe is connected with the suicide. And we know that's not an issue because he, in fact, did attempt to take his life that day. I don't think that is issue, and we'll certainly expect to argue that at trial. So, with respect to the continuous transaction doctrine, I think it's a stretch that the state is trying to connect it into that, is that this is part of some felonious event, and using Mr. Hahn's event, because clearly he's coming down afterwards, and that this is not part of that. And I quite honestly was in agreement with the court in its initial interpretation of the evidence that this is a P&D case. This is a premeditation deliberation case, and that's what it is all about. He either premeditated and deliberately intended to take this woman's life, or he didn't. And that really should be the issue that's been presented to the jury, should be presented to the jury. With respect to the lying in wait, I understand Mr. Fawcett's trying to provide himself with every possible theory he can think of. But that statement that he's relying upon of my client is only a portion of a statement where he says, I don't remember anything else. And it's subject to a great deal of attack, I think, from our point, because he doesn't remember cutting Mr. Hahn. He doesn't remember cutting himself. He doesn't remember any of the events of the day. He can't recount the events as they occurred in the household from the time he got there. It should be pointed out the fact that he was there for what at least is believed to be 15 to 20 minutes prior to Nation Hahn arriving at home, which would negate the lying in wait thing, because now the whole concept of the lying in wait is the ambush, is that you don't have to conceal yourself, but the idea is that you're going over there pretending to hide yourself to do this event. There's no evidence to that. And so it's a stretch. They're just trying to get every possible theory they can so that they can give the jury something to hang their hat on. It's like making spaghetti. They're trying to throw it up against the wall and see which one sticks. But that's not fair to Mr. Broyhill. That's not what this case was about. It never was. They came in here and they told the jury in their opening statement that, and throughout their evidence, that their belief is that there was a confrontation or a belief on the part of Mr. Broyhill that he was going to be confronted about this stuff that had been going on with the Brad Miller campaign account, and that this resulted as a result of that. No evidence there was a confrontation. In fact, there's evidence that there wasn't going to be a confrontation. We don't know what happened down in the room. There's just nothing to support the felony murder theory or the lying in wait theory. This is a P&D case. It's solely a P&D case, and that's the only one that we should be submitted. And so we respectfully, with the homicide charge, we agree. We agree with the court that what the court has proposed we're fine with that.
All right. And quite honestly, I'd not considered the lying in wait, and I'll need to read those cases to think about that one a little bit more. But Mr. Fawcett, let's think about the felony murder theory. And are you aware of any cases? Let's suppose there was a double homicide. It almost seems like it's tautological or circular argument to say, well, because there was a continuous transaction where there was a second murder, now the first one becomes a felony murder, but then that same logic applies to the second one as well. They both, under your theory, would benefit from both the premeditation, deliberation act, and the felony murder. Is that what the case law suggests?
Yes, yes, in the sense of case law, to my understanding, completely supports when you have more than one victim of more than one felony assault or even murder. One murder can be the predicate felony for the other felony murder, or a shooting of more than one victim. I don't have the cases right here. I'm quite confident the underlying separate felony assault. In fact, I think there's a case out there where, as to the same victim, there's a felony, I could be wrong, but there's a separate felony assault with maybe a machete as to injuring, and then the killings by another, of course, but it's in the same thing. I think that's an interesting case. But no, I think the cases out there fully support that felony murder in this case, where you have two separate victims all connected in time and place in one continuous transaction, and the felony is with a deadly weapon. It's a felony assault, absolutely. As to this motive, this is a charge conference evidence, and my opening speaks for itself. Motive, and the state has never said that there's, in this trial, there's a confrontation, an accusation from Ms. Hahn to the defendant. Again, these are all closing arguments. And premeditation can take the form of premeditation of the defendant formed the intent to kill the victim over some period of time, however short. It doesn't mean when you buy the knife you premeditate a murder, when you show up with the knife concealed that you're premeditating think about murder. That's what Mr. Arbor wants and will argue, and that's fine, that's permissible. But that's not what the law is, and that's not what the state's expected argument is going to be at all either. The context of all this is about what brings them together that whole month, and the money is one of those. But I just want to put down the record, and not just. But that's my answer to you about felony murder.
All right, well, that, I mean, I think Mr. Arbor's absolutely right that, the traditional or typical felony murder where the order of the murder and the felonious act is not necessarily relevant is, the armed robbery where the murder occurs first and then the property is taken from the person after their death.
Rape or an arson, the
Right.
body's dead, and they then burn the house down, and that's still felony murder.
Right. So that certainly is typical.
And in jury voir dire, I mean, I never mentioned theories of murder. This
Yes.
one came consistently from defense counsel.
The
possibility of a felony murder, premeditated and felony murder. I didn't mention any types of theories from the get-go. They were mentioning that. And he might, and I don't know about this, the record will say what it says in voir dire. There might have been one moment, Ms. Lafever doesn't recall this, about maybe even other theories. That might have been one time, one throwaway line by Mr. Arbor might have been said.
You're talking about during voir dire?
During voir dire, right. It's irrelevant to what the evidence in this case is and what the judge's instructions will be. But just, this is, so no, I'm sort of here with the line and weight stuff, and the felony murder from the state's point of view is well satisfied under the continuous transaction doctrine and the facts, the undisputed facts of this case. The nation was feloniously assaulted with that knife.
All right. Yes. And, if you want to remain seated during this portion, that's fine with me, please.
I kind of appreciate things. I hate to say that's rather disingenuous too. Your Honor knows. I'm not in a position, I'm not permitted, well, I could, but they wouldn't have to reply to a bill of particulars asking them to identify the theory upon which they're going to proceed on the case. Your Honor knows that. And I don't get to know what theories they're going to proceed on until we get to the time of trial. And quite honestly, with the fact pattern that has been provided, I'm rather surprised they're even adding the lying in wait, because it was, I think it's a stretch from the evidence that we've been given. But we certainly saw that they might argue for continuous transaction. But I think it's disingenuous to have the ability to not announce your theory until you get to the end of evidence, and then say to the defense that you're limited in your voir dire to how you're, so that you can't contemplate the possibility that all of that could be presented to a jury to consider. How are we supposed to how are we supposed to gauge the peremptory, the use of our peremptory challenges if we don't consider all possibilities that they may be faced with? Just as we ask about it doesn't mean we are conceding that it's going to be presented to them, but we certainly have to ask about it because we have to know how they're going to deal with that when it's presented to them. The concept of the lying in wait, to be honest with you, was so remote to me that had I thought about that, I would have brought it up in voir dire as well. So I think it's disingenuous to bring that up on the part of the state, that it was something I addressed in voir dire. That's certainly not a concession on the part of the defense. It's just proper procedure in evaluating how to exercise your peremptories.
I agree with that.
Thank you.
All right, well, we'll come back to this issue. I'll need to read and review some case law on both of these theories, the felony murder and the lying in wait, and I'll be happy to receive. Mr. Fawcett, you have...
I have various cases to cite. I don't really have clean copies.
That's fine. If you want to just give me the...
Yes, I think, starting with the pattern jury instruction of State v. Brown.
Those you've given, the lying in wait, I think you've already recited those. Brown, Wiseman, and Allison.
Do
we have cites?
yes, sir, let's see. Brown is 320 NC 179, and that probably will start taking you to other things. State v. Allison was the first one up, not having to be concealed. 298 NC 135. State v. Leroy, Leroux, 326 NC 368. That's a police officer's walking on a dark golf course and a person shoots him. I don't have any. I've got lots of others I can keep quoting.
No, that's fine.
Not for any specific.
That's all on lying in wait.
Yeah, those are all lying in wait. I think they'll take you to different other fact patterns. But
And what about continuous transaction?
continuous transaction, Your Honor, my quote is the well established from the case law as I understand it. I don't. Let's see if I continuous transaction. I think those come from State v. Fields is one that's often cited. I think 315 NC 191. State v. Thompson 329 NC 423. State v. Hutchins 303 NC 321. Those are some, as I understand it, for the bare proposition of the law of what the definition of continuous transaction is.
All right. And what I'm intending to do is we'll go for a while before the lunch recess. We'll take a lunch recess. I'll read some of this case law. We'll reconvene early afternoon to go on further. All right, let's move on.
Can I give you one? Let's see.
Yes, sir.
I'm sorry. Maybe State v. Atkins.
This is under what?
A line and wait, Mr. Arbor. State v. Aikens, maybe it is, a Supreme Court case from 1996. That's probably a pretty good one. 342 NC 567. State v. Battle.
We still in lying in wait?
Yes, I'm just trying to give different, sites. That's 322 NC 69. I think you'll find a variety of cases, and they all similar.
All right. So we'll come back and talk further on that issue later. Let's talk about lesser included offenses. Second-degree murder, I think, is one that
State agrees.
state agrees. Mr. Arbor.
Yes, Your Honor. I mean, I'll, for the record, I'll concede that the case law as it's interpreted is not conducive typically to a voluntary manslaughter. But my position has been in past cases, and it is in this case as well. And when you look at the charge on voluntary manslaughter, and I'm talking about the pattern jury instruction under 206.41, omitting of course the language regarding involuntary manslaughter. We're not suggesting that. That the elements: defendant killed the victim by an intentional and unlawful act. We could see that. Second, that the defendant's act was a proximate cause of the victim's death. It's not an issue. But would those two elements alone seem to satisfy the elements of voluntary manslaughter. They don't get too much in, they're kind of devoid of interpretation from the jury standpoint. I know the courts have had a very different interpretation of when it should be applied, because, and quite honestly, I'd be shocked if Your Honor would disagree with me on this, because I've been trying to get a straight answer from lawyers and jurists regarding why, explain to me what it is. And it always comes back to the one scenario that everybody says, which is the man who walks in on the husband and wife sleeping in bed, and then the person's responding to essentially it's the equivalent of an extreme emotional disturbance, and as a result of that, commits an act of murder on that person. And they say under that scenario, that's voluntary manslaughter. But they don't say in the legal definition of it that that's what it is. It's just that when you ask everybody, what is it, that's what they tell you. And to me, you can't have an instruction, a legal instruction, that is limited to a specific fact pattern. I think if you have that, I think it basically, it challenges the constitutionality of an instruction. And it's not that the instruction does say that, but when you ask about it, and I don't think Your Honor is going to disagree with me on that, because I imagine you've heard the same thing, that when they refer to it, they always say it's under that fact pattern. My interpretation of the voluntary manslaughter count is that it does incorporate a person responding to an extreme emotional disturbance, an event that causes them to act outside their normal thought patterns, and then in essence commit an act that brings about the person's death. Respectfully and with full awareness of what the case law is, and with a strong disagreement onto the record that there can't be just this limited scenario by which a voluntary manslaughter can occur, the one about the jealous husband or jealous lover or whatever walking in. We respectfully submit that there's a reasonable interpretation of the facts, that is what Mr. Broyhill was doing. He was responding to an extreme emotional disturbance in the middle of attempting to take his own life on that date, and that these events occurred as a result of that. And therefore, we would respectfully submit that the jury should also be allowed to consider as a lesser included offense of the event, should they decide that it's not premeditated and not deliberate, whether or not it falls into the category of a voluntary manslaughter. And would be satisfied with, we're not seeking to alter the language of the pattern jury instruction for voluntary manslaughter as it exists, but to submit it as it's written as a lesser included for the jury's consideration.
Awesome.
Judge, there's no evidence to support a voluntary manslaughter, which requires either imperfect self-defense, displacing malice, or legally recognized and adequate provocation displacing malice. There's no evidence.
Yeah, that certainly is the case law that the court has defined in fairly specific terms what the law permits.
I would just say, I just submitted, Judge, because in the standpoint of if the law exists that allows the jury to draw an interpretation of the evidence to a law that exists in our books, that would be a consideration for them to consider in determining what the defendant is actually guilty of. If you look at the language, it is something that they could interpret as being what happened here. And so I'm just saying, I understand how it's been interpreted by the case law, and I acknowledge it. I just think if you're going to have that language, it can't be limited to just that factual scenario, and therefore should be something for them to consider.
All right. So, Mr. Foster, your position would be is that it's the offenses would be first, second, and not guilty.
Yes, Your Honor.
All right, for the homicide. All right, and you're requesting, Mr. Arbor, a first, second, and voluntary manslaughter.
Yes, sir.
All right, and not guilty. Okay. We will discuss that one further. Let's move on then to the next substantive offenses. We've got attempted first-degree murder.
Oh,
I'm not aware of any lesser included offenses that would be appropriate there. And so that would just be pattern instruction. The only deviation would be is that there's a peremptory instruction on the deadly weapon. Mr. Arbor, do you want to be heard on the
deadly weapon issue, Your Honor?
well, no, on just the entire charge of attempted first-degree murder?
I haven't had a chance to read it completely, but if it's following the pattern, Judge, with the exception of the peremptory instruction, no.
Okay.
I'll double check it to
Yes,
see
sir.
that it is.
Yeah, and you'll certainly have time to read it. I'm looking more for broad overview at this time, and then.
No.
Then, all right. Next would be the assault with a deadly weapon with intent to kill, inflicting serious injury. On this one, it's the pattern instruction with the peremptory for the serious injury.
Ask the court to let the jury decide on the serious injury aspect.
All right, so you would not request a peremptory on. All right. All right, Mr. Arbor, any thoughts on the assault? And then I have the lesser included offense of assault with a deadly weapon, inflicting serious injury. And then
I suspect nothing as to the lesser. That we're fine with that. I suspect that the state's statement that it opposes the peremptory language on the serious injury, if I understand that's their position, is to help them establish the felony murder on Ms. Hahn.
Correct.
And
State gets uneasy about those things.
but we certainly don't want to make Mr. Fawcett uneasy about things. I think our goal, at least my goal on behalf of my client, is to present the instructions of the law that the jury is to follow in a way that makes sense to them. And I don't think you've ever heard anything from the defense contesting that Mr. Hahn did not sustain a serious injury. We would be arguing that they did. It sort of rides along with the facts of the case. To sort of get into this thing just for the state to be able to try to, somehow create a felony murder instruction, and I think that's what's happening, could create some confusion in the minds of the jury that we're contesting whether or not this thing is a serious injury. And I don't want that to happen on behalf of Mr. Broyhill, because he certainly acknowledges that these people were damaged as a result of his actions, and we want to be able to talk about that, and we don't want to have to be explaining up there why they have to make that determination when it's really not an issue. And it's really just an issue that's being offered to get to something else that we don't think should be offered in the first place. So we would oppose that. We have no problem with the peremptory language. We would oppose removing it, because I think it's confusing to the jury, and it could potentially be prejudicial to our client, and which in result we respectfully submit would be unfair to him.
All right. Okay. I'll look at that issue as well. Let's talk about, and then lesser included defense. Mr. Fawcett, do you want to be heard on that? I've heard no objection from the defense. All right. Then we move, it's aggravating factor. Let's talk about it, Mr. Fawcett.
Judge, I do think the statutory scheme is that if there's a conviction of structured sentencing offense that requires a judicial sentencing, that would be a separate proceeding where, how about just, and one of the reasons is, my understanding is, like the pretrial release. You can't probably, during the case in chief, get into, hypothetically, as he failed to come to court, I believe, on some minor motor vehicle matter, was arrested, bonded out, and had a court date. He's out on pretrial release. I mean, it's an aggravating factor. Let's say it's something, actually, armed robbery, In the state's case in chief on the lay, we can't, I don't have the pattern right in front, but I think the statute contemplates exactly that is a separate thing. It then allows parties to put in evidence about that if they so desire to get to that point. And I don't think that's...
All right.
Okay.
I would agree with that, Judge. We think this...
Okay. We can certainly pull it. I was unaware of the pretrial release. It certainly would be one that would be bifurcated, but I was not... I've certainly had instances where I've had aggravating factors that relate, such as this one, that took advantage of position of confidence that are just simply made part of it on the verdict sheet. But we can certainly pull that out and then allow for a bifurcated proceeding on just that topic. All right, now, so we've gone through the substantive offenses. Are there any requests or suggestions in general that you're aware of with respect to these instructions?
Generally always being cautious. Certainly the instruction about admissions, the state, particularly me, I always get very uneasy when we jump to the confession. The state would ask that it's that an instruction as to admissions being made and not the actual confession. That's again just.
All right, they're very similar, and I actually first started with admission. Then I think some questions in cross-examination I changed it to confession, but I think that it's could certainly put one or both. Mr. Arbor, what's your position on the patterned instruction for admissions versus confessions?
believe the testimony, this was a, what we would call a, what can be characterized as a confession. There's a difference between a confession and an admission. Because we only have portion of a statement, portion of what he recollects, I think I would tend to agree with Mr. Fawcett. It's more of an admission than a confession. I think 104.60 deals with admissions.
All right. I don't, I think you both agree on that, so I think and really the only difference is the word confession is used in 104.7 and the word admission is used in 104.6, so I'm happy to replace that. Mr. Fawcett?
Let's see, I think that was the only observations I had on the non-substantive matters.
All right. Mr. Arbor, any requests or further objections to looking particularly at the non-substantive ones? And again, you'll have an opportunity to review these, and we'll resume this conference after our lunch recess.
Thank you. I'm just taking a look at the just want to make sure there's some language in here. On the other substantive matters.
All right, so nothing further at this time?
No, not this time, Judge.
All right, well, in that case, we'll go ahead and recess till 2:30. And that'll give me an opportunity to review some of the case law you've cited and consider these theories of, it looks like really that's the only substantive charge that we're looking at is the theories of first-degree murder and then the urging by the defense to have a voluntary manslaughter instruction. Those would be the
And then the peremptory issue on the
right,
on serious injury.
right. That's
Sort of tied in.
still an open issue as well. All right, then we'll be in recess till 2:30. We'll reconvene our charge conference and go from there.
Superior Court stands recess 2:30.